This is a guide to workplace injury claims. Employers have legal obligations arising from legislation and a common law duty of care to ensure steps are taken regarding employees' safety from harm in the workplace, and employees also have duties to take reasonable care to look after their own safety. This employee should notify the employer of the accident and keep the information particulars of what occurred. Employers should have accident report forms which can be completed. Employers have various obligations in terms of reporting accidents to the Health and Safety Authority, for example, for accidents or dangerous occurrences or an incident involving a biological agent. Health and Safety Authority. Inspectors have powers to take actions when statutory contraventions are found, there's a risk of serious personal injury, by taking proceedings to the District Court for breaches of legislation. Employers should report accidents to the Health and Safety Authority when an employee has been out of work for 3 days due to injury arising from a workplace accident. Employers have common law duty of care obligations and statutory obligations to employees in terms of safety measures in the workplace. Under Section 6 of the Unfair Dismissal Act, a dismissal of an employee is deemed in law unfair if it is due to civil proceedings, whether actual, threatened, or proposed against the employer to which the employee is or will be a party, or in which the employee entitlement to full pay. After a work-related injury, to assess if an employee can obtain sick pay or illness payment when such an event occurs, one needs to review their employment contract. If there is no provision in an employment contract for salary payment when such an event occurs, then employers are unlikely to be obligated to pay an employee's salary unless there is a custom and practice in the workplace to do so. Workplace injury claims must be submitted to the Personal Injuries Assessment Board for assessment. If the case is dealt with and concluded at this point to the satisfaction of the parties, the entire time frame could be 9 months to 1 year. If the matter is not dealt with by the Injuries Board, the injured party may have the option of proceeding to court to seek a judgment from the court. You will firstly need to write the party responsible for causing the accident, stating the nature of the wrong, etc. Under Section 8 of the Civil Liability Act, 2004, this is called a letter of claim. Once the application Form A is completed, it must be sent to the Injuries Board with €90 or €45 as an application administration fee, depending on whether you submit your application by post or online. The application must also include the Medical Assessment Form B, which is completed by your doctor. Time limits. There are strict limits to adhere to when taking such a case. The Statute of Limitations necessitates workplace injury claims are commenced within 2 years, less 1 day from the date of the accident. After submitting your application to the Injuries Board, you should ensure you follow up with them to obtain confirmation of registration of the claim. Evidently, the paperwork you submit and obtain in return needs to be correct, and you should check this. Occupational Injuries Scheme. There are government schemes available to a person who is injured in an accident and cannot work. This can include Injury Benefit, Disablement Benefit, HSE-related Treatment Benefit Scheme / Medical Card Scheme. There is detail on injury benefit from the Government Department's website. There is detail on disablement benefit from the Government Department's website. Damages in legal cases of this nature are divided into 2 groups, namely general damages and special damages. Special damages can be loss of income, medical consultations, treatment fees, damage i.e. loss of car hire, medication, vehicle towing, travel, physiotherapy, damage to property, or other expenses incurred relevant to the accident. General damages are calculated with respect to consideration of the pain and suffering sustained. The nature and duration of the injuries will be examined together with the effect on one's life. Each personal injury claim is dealt with on an individual basis, however. The personal injury judicial guidelines do provide for guidelines regarding a potential range for compensation for a particular injury. The guidelines deal with general, not special damages. Court. If a person or party allegedly responsible for causing the injury refuses to have the matter assessed by the Injuries Board, the Board will issue what's termed an authorization, which then permits the person to commence legal proceedings, if they so wish, to have the matter adjudicated by a court. Whether the case should proceed to court or not would need to be discussed with your solicitor once the facts have been investigated and clarity in terms of negligence has been garnered. The Injuries Board is a state body that deals with personal injury claims, but it is not a court and has no judicial function. If you have any questions, our contact details are 01 546112 or 052 612 1999, or our email address is info@clearysolicitors.com, personal injuries. In contentious business, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement.